Yes, please, Mr. Mohan.
Yes, with pleasure, Lordship. Lordship shall like to mention item 9.
Ah.
Item 9. This relates to this relates to this state mental health care tools, which has to be framed by the state.
Still pending.
It's still pending, which has to be as mandated by the act. It has to be approved by the central government. It has been approved. Now,
Any indication to show that you have reminded the central government?
we have
You,
reminded.
you,
and
you
it
have
has been
actually
approved.
submitted that you have actually sent the thing to the central government.
Yes, it has
And
been
you
approved.
are waiting for the approval of the central government.
It has been approved, Your Lordship.
It has been approved by the central government.
Lordship, yes. In fact, on the last order, 28 February, the matter was brought before the notice of this court.
Okay.
So this court has directed that the approved rule be notified in the official gazette. That was the instruction given, Lordship. So they're supposed to bring the compliance
Okay,
report.
in the
Now-
official gazette.
Yes, yes, whether they have notified it or not.
No, now that Your Lordship, model code of conduct is in place. Model code of conduct will go till June 4, declaration of the result. So let this meet come out.
Is the model code of conduct an obstacle for publishing this thing in the official gazette?
No, but the model
You want to
code-
be on the safe side.
Yes. So long as the model code of conduct is in place, we cannot.
Okay, we will not mention that, but we give them some time to publish.
Lordship, also, I have one prayer, Lordship. In the affidavit, they say that 2 mental health review boards have been constituted. Lordship, that has not been placed before this honorable court regarding the appointments of the board, Lordship. So last time a
The
case,
members.
yes, Lordship, a case also arose where we were looking for the boards, Lordship, but we could not find it anywhere. So Lordship, if the appointments can also be placed before this court and the copy be furnished to us, so that we can assist. Lordship.
For the members for the mental health review board.
Yes, Lordship. The state submitted a affidavit saying that 2 mental health review boards has been constituted, Lordship. So
Let us see that. Okay, then let it come as per the list. Let
Let
us see
this
the
whether
file.
we come up on June 5, that is Wednesday.
No, I think madam has made some submissions, so let us see to that.
Lordship,
Okay.
otherwise, if on the next date, if that can also be placed before this honorable court.
The appointments.
Yes, Lordship. Since they stated that they've already appointed, but the copy has not been furnished, Lordship, so.
It has to be done, Your Lordship. Once it has been gazetted, then it has to function. Only problem is to make it in the gazette.
Let us see that order which you were holding. Let us see that. Mr. Mohamchan, the Leonard Senior Government Advocate, and Ms. Neetu Kosa, the Leonard Counsel for the petitioner. This was placed in the last, on the last date.
Yes, Lordship, the approval is.
Okay.
Yes, accordingly, yes,
Okay.
order was passed.
Mr. Moa, the Leonard Senior Government Advocate. 6 for 4 weeks time. To publish the state mental health rules framed under section 121 of the Mental Health Care Act 2007 in the official gazette. Stop. On the next date fixed, the Learned Council, the Learned Senior Government Advocate shall also come with necessary instructions as to the appointment of the personals for the
Mental health review boards.
mental health review board. Okay. Okay, after 4 weeks, ma'am. This is on record, ma'am. This is on record.
Dated 28 February, Lordship.
Ha ha ha. This is on record. Okay.
May I please, your lordships?
Yes.
I beg to mention hearing item number 16, 17 and 15, 16 and 17, lordship. These are all analogous matters, lordship. Lordship, initially it appears that Mr. N. Kavitsa was a learned counsel for the petitioner's lordship. But however, due to difficulties, it is approached the legal services lordship.
Yes.
And only this time I've been endorsed to take up for the petitioner's lordship. So I may be allowed 4 weeks time, lordship, to go through the records and accordingly.
Mr. Taka, you are also for?
My lord, I'm appearing for item number 15.
Oh, item 15, my lord. So you are a member.
16 and 17, lordship.
16 and 17.
Item number 16 and 17.
Okay. Mr. Takakichu appears for the appellant. Even in item 16, 17?
No, madam. I'm
In-
appearing only for item number 15.
Okay, in criminal appeal 2/2019. And MS Appeal Sanctum, the council appears for the appellant in criminal appeal 3/2019 and criminal appeal 4/2019. Stop. Mr. Kiangami, learned counsel, learned public prosecutor appears for the state respondents. MS Appeal Sanctum, the learned counsel submits that he has been recently entrusted to take up the case on behalf of the appellant in criminal appeal 3/2019 and criminal appeal 4/2019. And therefore 4 weeks time to go through the reports and to address the court. Prayer is allowed, listed up to 4 weeks.
Please, lordships.
Yes,
Lordship, I beg to mention item number 8.
yes, ma'am,
Yes.
item,
8.
Huh.
Lordship, I just received the Paraguay school. So Lordship, can you grant 3 weeks time to file affidavit as per the court direction?
MS Space Operator, the learned additional advocate general submits that he has received the Paraguay's comments only recently, and therefore he may be allowed 3 weeks time to file affidavit in opposition. Where is allowed, listed after 3 weeks.
Lordship,
May I please, your lordship?
Yes,
I beg to mention item number 5, your lordship. If I may be allowed 4 weeks' time to file my additional affidavit, your lordship.
on behalf of,
Nityo Koza.
on behalf of the petitioner. that
Yes,
means-
your lordship.
Yes. MS Senso, learned counsel for the petitioner, he is granted 3 weeks time to file additional affidavit. Okay,
Lordship, I'm appearing for respondent number 3.
okay, MS Senso appears for the respondent number 3, and Mr. L. T. Sanctum, learned additional AG appears for the state respondents. Okay.
Oblige, your lordship.
Please, Lordship,
Yes,
I beg to mention having item 19 on behalf of R.A. Rongmai.
He is for
For respondent number one.
one. No need to mention on behalf, you are there.
Yes, my lord.
What is your prayer?
Since the leading council is indisposed, so the matter may be fixed after 3 weeks.
Mr. Pankiri Chabo. The learned counsel for the appealant submits that.
Most likely respondent number one.
The learned counsel for the respondent number one submits that. The leading counsel is indisposed and therefore the matter may be listed after 3 weeks. Prayer is allowed, listed accordingly.
Look like.
May I please, lordships?
Yes.
I beg to mention hearing item number 18. Also, I pray that the matter may come after 1 week. I've taken consent from the counsel for the petitioner.
What is their review?
Lordship, the matter is regarding posthumous regularization. The petitioner husband was serving as LDA casual, and he had not attained 30 years at the time of his demise.
What is your prayer?
Lordship, for 1 week, maybe at all. I'm appearing for
Is the
two-
review before me?
No, my lord.
Or before my Lord Justice Woody?
Lordship, here the petitioner is not present today. He is for the respondent. I am for the
Respondent 2 and 4.
Oh, you are for respondent.
Yes,
You are for respondent 2 and 4.
yes.
Okay. Mr. M. Konyak. The learned counsel for the respondent number 2 and 4 submits that the leading counsel is,
Mr. Mojamed.
no, any reason?
Yes, some personal difficulties.
The leading counsel has some personal difficulties to attend the court today and therefore seeks adjournment of the case after. There is allowed, listed accordingly.
May it please your lordships.
Yes.
Lordship, I beg to mention item 12, your lordship. In this matter, your lordship, I'm yet to receive instructions, so I may be granted a further time of 3 weeks, your lordship.
MS. Okay,
No, no, no.
as Mary. The then a senior government advocate is granted 3 weeks time to file affidavit in opposition. Affidavit
Yes, your lordship.
in WA.
Lordship,
Affidavit in opposition. Prayer is allowed, listed accordingly.
I'm obliged.
May I please, your lordship.
Yes.
I beg to mention item number 4. Lordship, here in the earlier writ petition, we are for the petitioner. Here in WA, we are for the respondent. However, Lordship, I need to get the instruction from the client. We are still trying to contact. So kindly grant 4 weeks time. Lordship.
Close. Yes, Mr. Zatan Mule. Whether the appeal still survives.
Yes, my lord. I have no petition read by my learned friend.
No, I am asking you whether the appeal still survives.
Yes, my lord.
What is the appeal about?
Oh. To set aside and quash the imperial department of the single judge on 4/7/2000.
This is regarding that census,
Yes, my
something
lord.
to do with census.
Yes, my lord.
Yeah, what is your prayer?
Lordship, we are yet to get instruction from the client. We are still trying to.
You are
contact
for
the-
respondent?
Yes, Lordship. The sole respondent.
Who actually earlier represented this respondent?
No, Lordship, we are for the petitioner in the earlier writ petition, Lordship.
So you are for respondent here in appeal.
Yes, Lordship.
So who had earlier represented
Not
the respondent?
Asipizu.
Because no
Well,
name is reflected.
And they are saying that they are going to file Baklanamat. So I'm
Oh.
sure that Agapichu and Asipizu.
You have been recently engaged.
No, we are yet to engage Lordship in WL Lordship. We are trying to contact the client Lordship.
You have not been engaged.
Yes.
Your good name,
The Blue Marshal Lordship.
Mr. So-and-so. Learned counsel submits that. They submits that a short date may be given to enable him to file power on behalf of the sole respondents. Is allowed listed after 3 weeks. Okay.
Much obliged. For motion, item numbers 1 and 2.
Yes, who is for the applicant?
Lordship, my second by receipt.
Possible. Okay, next item. Possible.
For motion, item number 3.
We issue notice. Right, Mr. So-and-so. Learned counsel for the petitioner.
Outside notice on behalf of the respondents.
By filing the present writ petition, the petitioner is impugning the order dated 6/4/2023, passed in OA 8/2019 by the Armed Forces Tribunal, Regional Bench, Gauhati. Upholding the order dated 5/4/2023, discharging the petitioner from service. Issue notice to the respondents, returnable after 4 weeks. All the respondents. Mr. Yamawati, learned CGC, appears on behalf of all the respondents, and therefore no formal notice need be issued. The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned CGC within,
Oh,
They
we
have
have
already
already
served.
served.
Yeah, already so.
in the course of the day.
Right, for admission, item number 6 and 7.
Lordship, I'll be filing my affidavit within a week.
In
Within a week,
item,
6 and 7. This is week. This is week.
Like this, Your Lordship.
yes,
I'm appearing on behalf of Mr. N. Mojoy in item number 6, PIN 23 of 2020. Lordship, I pray that let the matter come up after a week, Lordship.
last time you made a mention that the new mission director is yet to be appointed.
Lordship, Lordship.
Has it been appointed?
I'm not very sure, Lordship.
And Mr. Yamawati, you are filing your wakalat nama on behalf of respondent number 6,
For the Union of India.
Union of India respondent number 6. Six.
Petition.
Six. And who is for 7? Social Welfare Department.
Lordship, but we are performer only, Lordship. We are not implementing party, Lordship.
Okay.
4 and 7.
So you are making a mention on behalf of Mr.
N. Mojoy, Lordship,
N.
for the
Mojoy.
medical.
Yes, ma'am.
Lordship, I have no objection.
MS Nito Koza. Learned Counsel for the petitioner. Kohima. MS Apila Sanctum. On behalf of Mr. N. Muzui. The Learned Counsel for the respondent number 1. For the respondent number
3, Lordship.
3.
3, Mission Director.
Yes. Mr. Yamarwati, then stop. NMS Apila, okay, NMS Apila. On behalf of Mr. N. Muzui, the Learned Counsel for the respondent number 3. Thereafter, Mr. Yamarwati, the Learned CGC submits that he will be filing the power when? Oh, he will be filing the, you have received the instructions. He has received the instructions and will be filing the affidavit. And will be filing the affidavit. Yes. By the order dated 3/4/2024, adjournment was sought by the Learned Counsel for the respondent number 3 on the ground that the new mission director is yet to be appointed. On the next date fixed, Mr. N. Mozui shall apprise this court as to whether the new mission director has been appointed. Stop. Mr. Yamawati, the Learned CGC, is also allowed 2 weeks' time to file affidavit in opposition, listed after 3 weeks. Okay.
Lordship, in the meantime, for respondent number 4 and 7, we are not filing the affidavit since we are not a necessary party also.
MS Apila Sanctum. Learned Counsel for the respondent number 4 and 7 submits that no affidavit will be necessary on behalf of the same respondents.
Please, Lordships.
For admission, item number 10.
Yes.
Lordship, this is a condonation seeking for 569 days. Between the companion with appeal, Lordship.
Mr. Lima,
Yes, Lordship.
are you still objecting? Are you still in that mood?
Lordship, yes, Lordship. Lordship, in this case, Lordship, the judgment was passed on 26/4/2022. Thereafter, Lordship, the state government, by later dated 18/5/2022, that is within a period of 1 month, have directed the department to file an appeal. That was in the year 2022. However, the present appeal was filed only in the month of December 2023. And in the IE, they have failed to give the sufficient cause. What is what prevented them? And Lordship knows is a several judgment passed by the appeals court also. The number of these does not matter, but whether the applicant has shown the sufficient cause. In the present application, Lordship, they have failed to show the sufficient cause. Lordship, yes. PNR department has requested the PWD department to refer for appeal. But again, PWD department have made attempt to accommodate the petitioner, Lordship. And if my Lord may turn to page 17 of my affidavit, Lordship. This is the letter written by the
Now, let us first see your grounds. Let us first see your application. Let us first see. You explain the ground as to why actually delay of 559 days was occasioned.
The grounds they have taken in paragraph 2.
Let them submit. I will come to you. Let them submit.
Lordship, so paragraph 2, Lordship, page 17, Lordship. Here, page 17. By this letter,
Page
17, Lordship.
No, just show us the ground first. Where have you stated the grounds? Which paragraph?
Page 3, Lordship.
Page 3 of the application.
Lordship.
Page 3.
Lordship, I may be allowed to read then in this case, Lordship. That the applicants respectfully beg to state that as
You are
the-
reading para 2.
Yes, part 2, Lordship. That the
Para
applicants.
2.
Yes, Lordship. We can respectfully beg to state that as the date of the passing the impugned judgment on order passed in WPC 229/2021 falls on 26/4/2020. The 30 days window period for filing as per the Limitation Act 1963 has expired on 25/5/2022 in the present case. Counting from 26/5/2023, there is an unintentional delay of 569 days in filing the accompanying writ appeal on account of the following reasons. A. In view of the direction dated 26/4/2022 passed by the learned single judge in WPC 2029, so 229/2021 turned out contrary to the scheme for regularization and absorption of work charge and casual employees and revision pay wages 2015, wherein the petitioner has not completed 30 years of service to qualify to avail the benefit of a scheme by a letter dated via number so dated 18/5/2022. PNR department had requested the secretary Department of Work and Housing Nagaland to prefer and appeal against the judgment order dated 26/4/2022 passed in writ petitions number 229/2021. B. Despite of the letter dated 18/5/2022 issued by the PNR department in its sincere endeavor, Lordship, to comply with direction 26/4/2022 passed by learned single judge in writ petition number so and so, responding the letter by number so and so dated 31/5/2022 of the engineer in chief and PWD by a letter via number so and so dated 2022, the Department of
I am not getting this. Despite the letter dated 18/5/2022 issued by the PNAR department in its censor endeavor to comply with the directions so and so passed by the learned single judge, responding the letter. How does this sentence?
Lordship here, the PNAR, the engineer in chief has written a letter to the government.
No, responding the letter dated 31/5.
Yes, that is the letter written by the engineer in chief, Lordship. He has written to the secretary, and PWD, the president of the institution of the case, Lordship, order of the impine order, Lordship. So
No, why chief engineer took so long? The letter was written by PNAR department on 18/5.
Yes,
correct.
Lordship. Yes,
18/5.
yes. Despite of the letter, that was attempt was made to accommodate the petitioner, Lordship. So this come after the PNAR letter, Lordship. And responding to the letter of the engineer in chief, the secretary of the PWD again written back to the chief engineer, Lordship. And there he has requested the chief engineer in chief to indicate essential vacant post against a petitioner, Srimati Yang Lula, for taking up
We just wait responding this sentence, you have suddenly gone off track. Responding the letter wide number so and so dated 31/5.
I'm sorry, I have to make the sentence short. Make it longer.
No, passed by the learned single judge in WPC 229/2021. That is okay till that. Then you are suddenly going off track. Responding the letter wide.
Despite of the letter of the PNR, what I'm trying to say was, yes,
Responding the letter so and so. I don't know whether my brother has actually. My brother, we are finding it difficulty because you suddenly changed the track.
what I'm trying to say is, the letter was issued by the PNR to prefer an appeal. And thereafter, in spite of that letter, engineer in chief has written a letter to the secretary.
Engineer in chief has, despite that, the engineer in chief has written the letter dated 31/5/2022.
Yes, to the secretary, PWD, and
Just wait,
responding to that letter by letter number dated 26/2022. This the government has requested the engineer in chief to indicate essential post to accommodate the petitioner, Lordship.
Responding the letter so and so dated 31/5/2022 of the engineer in chief PWD by the letter number so and so, the Department of Works and Housing. Here, the department represents the government.
Yes. Both the secretary was there, then secretary as well as engineer in chief were there, Lordship.
To indicate. You have mixed up everything. You have mixed up the merit of the case as well as the reasons for condemnation. You have mixed up everything. That is why we are actually finding it difficult to. Condonation means only on the grounds why actually there was a delay. Finish, not on the merits.
So, here, Worship, I'm trying to show that all the time was spent.
By which order or letter the department to accommodate the petitioner was rejected? By which letter or
Yes.
by which order?
Yes,
The steps taken by the department to accommodate the petitioner
Worship.
by appointing him her in an ex post post facto post was
Worship.
rejected.
Still though, it's not as stated in my page 5.
We are not understanding your petition. That is why we are asking you.
Yes, Worship. No, there's no no rejection informal has come about yet, Worship. Before a decision could be taken, Worship.
Meanwhile, before decision could be arrived at, notice of filing of COP. Endeavor, you see or see, endeavor has been made to overcome the judicial technical complexity caused by the direction dated 26/4/2022 passed by the learned single judge, which is in conflict with so and so, and at the same time, endeavor has also been made for respectful compliance. Let us see your annexure, whether we can understand anything out of your annexures.
So, Worship, page 18. Page 18 is the impugn order, Worship. Not page 17 is the impugn order, Worship. Then page 18, Worship. Page 18.
17, 18.
Sorry, page 17. Page 17. Worship. Page 17 is the letter by which the secretary of the PNR has written to the PNR department has written to the secretary and PWD preferred against the imputed judgment, Worship.
Then what
by-
is your page 18?
Page 18 by letter dated 31/5/2022, the engineer in chief has written to the secretary and apprising of the at page relevant portion is page 19, paragraph 2, Lordship. Apprising of the judgment, impugned judgment, Lordship.
Paragraph 2.
Yes, paragraph page 19, Lordship. Then next page 20. Now the department has written to the engineer in chief to indicate ascension clause. Okay, that is by letter dated 20 June 2022, Lordship. Then by letter dated 22/9/2022, again the engineer in chief has written to the government indicating ascension clause, Lordship. Indicated ascension clause. But in between, thereafter, the records were not recorded in the office notice, but some attempts were made to accommodate. But before any decision to be at right F, by memo dated 8 June 2023, Lordship, the process of contempt proceedings against state respondents were intimated, Lordship. And thereafter, state here is not.
What happens? What happens after 22 September 2022?
Lordship,
What is the explanation?
Lordship, I've that one explained in page 5D, Lordship. Sorry.
Page 5.
D, Lordship.
Page 5D.
Yes, before.
There is
at
no
the
D.
point- Yes,
There is no D in page 5.
page 5.
Oh, D.
Yes, Lordship, before the official reports could not be maintained, but informally, some attempts were made in between, Lordship. And before any decision could be arrived at, uh, the con- the contempt memo was served, Lordship. So, though the process was as speed as desired, Lordship, but some attempts were made, sincere attempts were made to accommodate the petitioner, albeit the irregularity of the process, Lordship, though which is against the contrary to the scheme laid down in the OM for regularization of the work charge employee.
Okay. What is this, page 23? This is the order releasing the petitioner on superannuation.
Yes. Now, even the this is the indication of the post, Lordship. Indication of the post.
After this, what happens? You just see your annexure D, page 20.
Page 20. After that, a post was indicated, Lordship, by
After this,
a post was indicated, Lordship.
where have you stated? Where is the letter? Any letter written indicating
Yes,
the post?
Page 21, Lordship.
Page 21. Expose postal regulars. Okay, so after this,
After
when
this,
steps were being contemplated to accommodate the petitioner, contempt petition was filed.
Yes,
The contempt
some months
petition.
were, exhausted, Lordship. Though those things could not be carried out in a formal notice, but attempts were made, Lordship.
So attempts were made to accommodate.
Yes, but then before any decision could be arrived at, I must admit, it wasn't as speeded as desired, but then the contempt petition came, Lordship.
So
Then-
after the contempt petition came, there was a deliberation to file the contempt. There was a deliberation between the department and the state respondents to file the contempt against the order passed by the London Civil Judge. Correct. After the contempt was filed,
Yes,
there was a deliberation between the department and the state respondents to take up the matter in appeal.
Lordship.
And that is how actually it was
Yes, yes, Lordship.
it was decided to file an appeal
Yes, yes,
along
Lordship.
with this application.
Lordship. So the issue is if the kind of direction given the scope was too wide, unless the case is heard on merit, Lordship, again, Lordship, the ramification the state incur upon the state, especially financial implication, because the case of the petitioner is not alone, Lordship. So though admission in the writ petition, we are saying that appeal has to be dismissed, but if at least the scope can be narrowed down and other cases, unwarranted other cases are not allowed in.
Don't bring the other
Oh,
cases.
okay.
Don't bring the other cases. You just we are just on the condemnation.
Lordship. So unless the matter is heard, Lordship, the government suffered substantial injustice, Lordship. And the purpose and the intent of the work charge policy laid down by OM 17.320 to be defeated. And here in the European judgment, even the UO note was quashed, Lordship, before its office noting was by number UO note 207 18/7/2020 was quashed before it attains its finality also. So some serious.
Your note means
office noting, Lordship,
of what?
by issued by the PNR pertaining to the case of the petitioner, Lordship. Something were quashed in the European judgment, Lordship. So before it's so these kind.
Where is that? Where is that UO note?
I've not annexed here in the
Yeah, where have you stated?
I've stated in first paragraph, Lordship. First paragraph, page 11, page paragraph. Page 2. May I read, Lordship? That the applicants are preferring the present accompanying with appeal against the European judgment order dated 26/4/2020 pass in with WC 2/29/2021 by learned single judge of this honorable court, by which the learned single judge has directed the state respondents to regularize the work charge service of petitioner as sweeper within a period of 3 months from the date of receipt of a copy of the instant order dated 26/04/2022, entitled her to get pension and pensionary benefits inter alia, having interfered in the unenforceable right of the petitioner by quashing and setting aside the impugned note given under UO 207.
This also was quashed aside.
Yes.
How? How UO note can be quashed and set aside? This is a completely interdepartmental communications.
So at least let this things may at least if finally for all these reasons we have come back, Lordship.
Okay, Mr. Limahuba, we allow with cost. We allow with cost. I think government has explained.
As you rightly pointed out, after the judgment was passed, the government have taken some steps to accommodate the petition, the writ petition. And as per the statement made in the application as well as the annexure annex in this application, the last communication was 22 22nd September 2022. That was the last communication.
Yes, that was the last communication. Then there
And
was deliberation.
Condemn notice was received on 8 June 2023.
When have they filed this application? It is in December 2023. So we don't find much delay.
No, no, no. See, from the last communication was 22nd September 2022. And after we received the notice on the contempt petition, that was on 8 June 2023. That means 11 months. There's no explanation about the period of 11 months. After we received the contempt notice, they are not woke up in the application of the steps to file the prison appeal. Where's the explanation about this 11 months? It's not. And as for this judgment passed by the ethics court action, unless sufficient cause is shown, the delay should not be condemned. We are allowed to rely just on one citation, one paragraph, just one paragraph.
Yes, Mr. Kevin, do you have submissions? Citations?
Motion,
Do you have
yes.
citations? Let us take your citations also. Let us. We are allowing, but we'll take your citations. But we have decided tentatively. Yes, let us see.
Lordship, as you know very well, the state of Nagaland versus Deepak Ao and others, Lordship.
2005 Supreme Court. Where is that para? Which is that para?
15, Lordship.
Just wait, 2005. 3 SSC 752. Para?
Para 15, Lordship. May I read, Lordship? It is axiomatic that decisions are taken by officers, agencies, proverbially at a slow pace and a cumbered process of pushing the files from table to table and keeping it on the table for considerable time, causing delay, unintentional or otherwise, is a routine. Considerable delay of procedural red tape is the process of their making decision is a common feature. Therefore, certain amount of latitude is not impermissible. If the appeal brought by the state are lost for such default, no person is individually affected. But what is the ultimate analysis suffer is public interest. The expression sufficient cause should therefore be considered with pragmatism, a justice-oriented approach, rather than the technical detection of sufficient cause for explaining everyday delay. The factors which are peculiar to and characteristics of the functioning of the governmental conditions would be cognizant to and requires adoption of pragmatic approach in justice-oriented process. The court should decide the matters on merit unless the case is hopelessly without merit worship. No separate standard. I think worship for here this will suffice. Then or may be allowed to complete. No separate standards to determine the cause laid by the state vis-a-vis private litigant could be laid to prove strict standards of sufficient cause. The government appropriate level should constitute legal cells to examine the cases whether any legal principles are involved for decision by the court or whether cases require adjustment and should authorize the officers to take a decision or give appropriate permission for settlement. In the event of decision to file appeal, the prompt action should be pursued by the officer responsible to file the appeal, and he should be made personally responsible for lapses, if any. Equally, the state cannot be put on the same footing as individual worship. The individual would always be quick in taking the decision of whether he would pursue the remedy by way of an appeal or application, since he is a person legally injured, while the state is an impersonal machinery working through its officers or servants. Worship. Worship. Then the other citation. This is I guess this is an order passed only last year. Worship.
Yes.
October 9, 2023.
This is in civil appeal number, just wait. Where?
Most relevant would be
Which para?
page paragraph 16, page 7.
Para?
Paragraph 16.
Para 16.
Yes.
This is a very famous case.
Yes, 17, 19.
16. You are reading page 16.
No, no.
Para 16.
Yes, sir. But I want to point out some of the relevant paragraph sections.
Para 16.
17, 19.
17. Para 16, 17.
19.
19.
24.
24.
25.
25.
26.
26.
27.
27.
29.
29.
36.
36.
And 37. Worship.
37. Okay, wait. 16.
In
Yes,
collector, land acquisition, Anandinath and another versus Misti, Katiji, and others. The relevant High Court did not condone the delay of 4 days in presentation of an appeal by the collector in an accusation matter for which the court rejecting the application under Section 5 of the Limitation Act was carried in appeal. This court opined that the legislature has conferred power on Section 5 in order to enable the courts to do substantial justice in part by disposing of matters on merits. It was further held that expression sufficient was employed by the legislature is adequately elastic to enable the courts to apply the law in a meaningful manner which subserve the ends of justice. That being the life purpose for the existence of the institution of court, despite the liberal approach being adopted in such matters which are termed justifiable, the court lamented that message has not percolated down to all the other courts in the hierarchy, and accordingly emphasis was laid on the courts adopting a liberal and justice-oriented approach. The following passage from the decision is reflective of the court's realization that as such a liberal approach is adopted on principle as it is realized that when substantial justice and technical considerations are pitted against each other, cause of substantial justice deserves to be preferred. For the other side cannot claim to have vested the right in injustice being done because of a non-deliberate delay. It must be grasped that just judiciary is respectful not on account of its power to legalize injustice on technical grounds, but because it is capable of removing injustice and is expected to do so. 17, I've already
Okay.
This already been shown.
Then 19.
Then 19. Langka Venkata Solu, that versus state of Andhra Pradesh and others, happened to be a case where this court set aside the impugned judgment condoning both a delay of 833 days in finding the petition to set aside the dismissal ordered by the relevant High Court, along with the delay of 3,703 days caused by the respondents agreeing on record the legal representatives of the appellant. The court also observed that whilst the High Court admonished the concerned government leaders for their negligence in prosecuting the appeal before it and not providing a sufficient cause for delay, it nonetheless proceeded to condone the delay despite holding the same to be unjustifiable portion. Then coming to 24, Worship.
Coming to, you are skipping 19?
Yes, yes.
Oh, 19, okay, okay.
Yes.
Now you are coming to,
Worship, I read 19, Worship.
you are coming to 24.
24, Worship.
Ah.
22 and 23 are also to some extent in my favor, Worship, but more relevant is 24. 24, actually 25. Since
24.
Here, yes, 24.
Read 24, let us see.
We may profitably refer here and there to some other decisions of this court for the purpose of the
24, not necessarily.
yes, not necessarily.
Then 25, read.
Yes. G. Rama Gauda versus Special Land Acquisition Officer, while summarizing the position of land and law on sufficient coast, had the same occasion to observe that the contours of the area of discretion of the court in the matter of condonation of delay in filing appeals have been set out in a number of pronouncements of this court. It was observed to be true that there is no general principle saving the party from all mistakes of its counsel, noting that there is no reason why the opposite side should be exposed to a time-barred appeal if there was negligent, deliberate, or gross inaction or lack of bona fides on the part of the party or its counsel. It further observed that each case would have to be considered on the peculiarities of its own special facts. However, this court reiterated that the express sufficient clause in Section 5 must receive a liberal construction so as to advance substantial justice, and general delays in preferring appeals are required to be condoned in the interest of justice. Where no gross negligence or deliberate action or lack of bona fides is imputable to the party seeking condonation of the delay. This was followed by these words. In litigation to which government is a party, there is yet another aspect which perhaps cannot be ignored. It appears brought by government are
If appeals. If
Oh,
appeals.
sorry, in appeals. If appeals brought by government are lost for such defaults, no person is individually affected. But what is the ultimate analysis suffers is public interest. The decisions of government are collective and institutional decisions and do not share the characteristics of decisions of private individuals. Therefore, in assessing what in a particular case constitutes sufficient cause for purposes of Section 5, it might perhaps be somewhat unrealistic to exclude from the consideration that go into the judicial verdict. These factors which are peculiar to and characteristic of the functioning of the government. Governmental decisions are overly slow encumbered as they are by a considerable degree of procedural red tape in the process of their making. A certain amount of latitude is therefore not impermissible. It is rightly said that those who bear responsibility of government must have a little play at the joints. Due recognition of this limitation on the governmental functioning, of course, within reasonable limits, it's necessary if the judicial approach is not to be rendered unrealistic. It would perhaps be unfair and unrealistic to put government and private parties on the same footing in all respect in such matters. Implicit in the very nature of governmental functioning is procedural delay, incidental to the decision-making process. Paragraph 26 of it. MC Katiji Supra was also noticed by a bench of 3 honorable judges of this court in State of Haryana versus Chandramani, where we find the following discussion. When the state is an applicant praying for condonation of delay, it is common knowledge that on account of impersonal machinery and inherited bureaucratic methodology imbued with the note-making, file pushing, and passing on the buck it holds, delays on the part of the state is less difficult to understand, though more difficult to approve. but the state represents collective cause of the community. It is axiomatic that decisions are taken by officers, agencies, verbal at slow pace and a cumbersome process of pushing the files from table to table and keeping it on the table for considerable time cause delay, intentional or otherwise, is a routine. Considerable delay of procedural red tape in the process of their making decision is a common feature. Therefore, certain amount of latitude is not impermissible. If the appeals brought by the state are lost for such default, no person is individually affected, but what is the ultimate analysis suffer is public interest. The expression sufficient cause should therefore be considered with pragmatism in justice-oriented approach rather than the technical detection of sufficient cause for explaining every day's delay. The factors which are peculiar to and characteristic of the functional of the governmental conditions would be cognizant to and requires adoption of pragmatic approach in justice-oriented process. Paragraph 27 of this court in special Texildar land acquisition versus KV Aisuma had the occasion to observe that it would not be necessary for the state to provide a day-to-day explanation of delay while seeking condemnation of the same. The same relevant observation therein read as follows. It is now settled law that when the delay was occasioned at the behest of the government, it would be very difficult to explain the day-to-day delay. The transaction of the business of the government was being done leisurely by officers who had no or evinced no personal interest at different levels. No one takes personal responsibility in processing the matters expeditiously. As a fact, at several stages, they take their own time to reach a decision. Even in spite of pointing at the delay, they do not take expeditious action for ultimate decision in filing the appeal. This case is one of such instances. It is true that Section 5 of the Limitation Act envisages an explanation of the delay to the satisfaction of the court, and in matters of the Limitation Act made no distinction between the state and the citizens. Nonetheless, adoption of strict standard of proof leads to grave miscarriage of justice, public justice. It would result in public mischief by skillful management of delay in the process of filing the appeal. The process of the court should be pragmatic but not pedantic. Under these circumstances, the subordinate judge has rightly adopted the correct approach and had condoned the delay without insisting upon every day's delay in filing the review application in the light of the law laid down by this score. The High Court was not right in setting aside the order. Delay was rightly condoned. Then, Worship, paragraph 29, Worship. Considering the aforementioned decision, there cannot be any quarrel that this court has stepped in to ensure that substantive rights of private parties and the state are not defeated at the threshold simply due to technical considerations of delay. However, these decisions notwithstanding, we reiterate that condonation of delay being a discretionary power available to courts, exercise of discretion must necessarily depend on the sufficiency of the cause shown and the degree of acceptability of the explanation, the length of delay being immaterial. Sometimes due to one of sufficient cause being shown or an acceptable explanation being preferred, delay of the shortest range may not be condoned. However, in certain cases, delay of long periods can be condoned if the explanation is satisfactory and acceptable. Of course, the courts must distinguish between an explanation and an excuse. An explanation is designed to give someone all of the fact and lay out the cause for something. It helps clarity the circumstances of a particular event and allows the person to point out that something that has happened is not his fault. If it is really not his fault, care must, however, be taken to distinguish an explanation from an excuse. Although people tend to see explanation and excuse as the same thing and struggle to find difference between the two, there is a distinction which, though fine, is real. An excuse is often offered by a person to deny responsibility and consequences when under attack. It is sort of a defensive action, calling something as just an excuse would imply that the explanation of preferred is believed not to be true. Thus say there is no formula that caters to all situations, and therefore each case for condonation of delays based on existence of or absence of sufficient cause has to be decided on its own effect. At this stage, we cannot but lament that it is only excuse and not explanation. There are more often accepted for condonation of delays to safeguard public interest from those hidden forces whose sole agenda is to ensure a meritorious claim does not reach the higher courts for adjudication. Washington, paragraph 36. Paragraph 36. Page 90. We can profitably refer to Kotin Lamkan Supra. This is 2019, okay? Cited by Mr. Sen, where the same bench of three honorable judges of this court, which decided University of Delhi, this is 2020 lordship cases, was of the view that impersonal nature of the state's functioning should be given due regard, while ensuring that individuals defaults are not nitpicked at the cost of the collective interest. The relevant paragraphs read as follows. But while concluding as above, it was necessary for the court to be also conscious of the bureaucratic delay and slow pace in reaching a government decision and the routine way of deciding whether the state should prefer an appeal against a judgment adverse to it. Even while observing that the law of limitation would harshly affect the party, the court felt that delay in the appeal filed by the state should not be condoned. 8. Regard should be had in similar such circumstances to impersonal nature of the government's functioning where individual officers may fail to act responsibly. Thus, this in turn would result in injustice to the institutional interests of the state. If the appeal filed by the state are lost for individual default, those who are at fault will not usually be individually affected. Last paragraph, Lordship. Having thus told serious consideration to the rival contentions, we feel that the High Court decision to condone the delay on account of first respondent inability to present the appeal within time for reasons assigned therein does not suffer any error warranting interference. As the aforementioned judgment have shown, such an exercise of discretion does at times call for liberal and justice-oriented approach by the courts, where certain leeway could be provided to the state. The hidden forces are at dark in preventing an appeal by the state being presented within the prescribed period of limitation, so as not to allow a higher court to pronounce upon the legality and validity of an order of a lower court and thereby secure unholy gains can hardly be ignored. Impediments in the working of the grand scheme of government functions have to be removed by taking a pragmatic view on balancing of the competing interests, Lordship. So, Lordship, I hope this is the citations. I hope with this, my case will be satisfactorily covered, Lordship. And I pray that my petition may be allowed.
Yes.
Pleasure. In the matter of condemnation of guilt, in all the judgment, the applicant they have to show the sufficient cause. And then the judgment without the medal kind of at Parabimina. Sufficiency of sufficient cause. That is sufficient.
Government has to be shown some latitude.
Worship, whereas in the case of the Postmaster General, Worship, this was decided in the year 2012. The 2012 voluntary ACC 563. Which have submitted a list of books. I might be allowed to refer to the 3 paragraphs. Paragraph number 27, 28, and 29. Worship, paragraph 27, 28, and 29. May I read Worship, paragraph 27? It is not in dispute that the persons concerned were well aware or conversant with the issue involved, including the prescribed period of the mediation for taking up the matter by way of filing a special leave petition in this court. He cannot claim that he have a separate period of limitation when the department was possessed with competent persons familiar with court proceedings. In the absence of plausible and acceptable explanation, we are posing a question why the delay is to be controlled mechanically, Lordship, merely because the government or a wing of the government is a party before us. Though we are conscious of the fact that in the matter of condonation of delay, when there was no gross negligence or deliberate inaction or lack of bona fides, a liberal constitution has to be adopted to advance substantial justice. We are of the view that in the facts and circumstances, the department cannot take advantage of various earlier decisions. The claim on account of impersonal machinery and inherited bureaucratic methodology or making several notes cannot be accepted in view of the modern technologies being used and available. The law of limitation undoubtedly binds everybody, including the government. In our view, it is a right time to inform all the government bodies, which is important, that agencies and instrumentalities, that unless they have reasonable and acceptable explanation for the delay, and there was bona fide effort, there is no need to accept the usual explanation that the file was kept pending for several months, years, due to considerable degree of procedural red tape in the process. The government departments are under a special obligation to ensure that they perform their duties with diligence and commitment. Condonation of delay is an exception and should not be used as an anticipated benefit for the government department. The law shelters everyone under the same light and should not be swelled for the benefits of a few. I also refer to another judgment. This is reported in 2014, volume 11, SCC. Page 351. 2014, 11, SCC, 351. Your Lordship, in this judgment, Your Lordship, the judgment passed by the apex court in the state of Nagaland versus Libokau, that was also considered, Lordship, well passing this judgment. Your Lordship, I'm allowed to refer to only one paragraph, paragraph 10.
Paragraph 10.
Yes, Lordship. The court should not adopt an injustice-oriented approach in rejecting the application for condemnation of delay. However, the court, while allowing such application, has to draw a distinction between delay and inordinate delay for one of bona fides of an inaction or negligence would deprive a person of the protection of Section 5 of the Limitation Act 1963. Sufficient cause is a condition precedent for exercise of discretion by the court for condoning the delay. This court has time and again held that when mandatory provision is not complied with and the delay is not properly, satisfactorily, and convincingly explained, the court cannot condone the delay on sympathetic grounds alone. Your Lordship, in the present case, as I've already pointed out,
And your third submission, this one? Yes,
Lordship, as I've already pointed out, the last initiatives which they have taken was on 22nd September 2022. And after they received the notice of contempt on 8 June 2023, that means after a gap of Lordship more than 10 months, they were just sleeping over the matter. This is a deliberate and intentional delay. And the judgment which I've cited is squarely covers my case.
yes, next.
Lordship, that's all.
Only two. Where have you stated your objections? Well, what is this? Rule 2, Chapter 5A of Gauhati High Court rules?
Lordship, that is also objected. This application is not filed under Section 5 of the Limitation Act. Chapter 2, Chapter 10, 5E of Rule 2E. Lordship speaks only about for filing an appeal, not for condemnation of delay.
Filing an appeal.
For an appeal, not for condemnation of delay. Lordship, it's very true. I thought this issue is already discussed last time, so I thought this is already settled. Page 56, Lord. Lordship, page 56. Lordship.
Yes, wait, yes, wait. provision which they have for the application. So you- what is the process of this matter? Mr. Yeah, Nami, how do we proceed your application on the basis of Rule 2, Chapter 5?
Lordship, because the second sentence clearly says, the language of the limitation act is also same, Lordship. The division bench may condone the delay.
Where,
The division bench may condone the delay in filing any appeal if insufficient cause is shown, Lordship. It's very clear, Lordship. Even the other day, we have discussed, Lordship, and I think that's something.
Yes.
Yes.
Yes, Mr.
And in other cases also, I have cross-checked, Lordship. It's not always necessary that limitation act has to be inserted. If my
No, no, no. In fact, actually, you have filed this petition application under this Rule 2.2 of Chapter 5. If not, limitation is not applicable, limitation act is not applicable in writ matters. So writ appeal is a continuation of the writ petition. So it's not applicable.
continuation application.
But you are also right, when you actually file this application under this provision. The division bench may condone delay in filing an application. There is nothing wrong with this. Okay. Yes, Mr. Lima, where,
Lordship, that's all. Lordship, I leave it to Lordship.
uh, we want to be more liberal. We want to be more liberal. We want to let the party contest on merit. That will serve the ends of justice. That is what we feel.
Lordship, if the cause has to be imposed, Lordship, the cause should not be given to me.
You are not willing to accept the post.
No. If the cause has to be given, that may be given to the bar. Not me.
Given to the
Bar, High Court bar. High Court bar.
High Court bar. Yes, Mr.
Lordship, if that is at all to be imposed, I must say that the court is very generous, but my prayers to be lenient, Lordship. Because again, we are wasting a lot.
The portion of course is a recent judgment which is reported in 2019 Balancing Institute, which came up from the state of Manipur in the Supreme Court. In the judgment was passed by Justice Vishnu. Regarding the imposition of cost, that's what
Again, some cause imposed, then again, departments.
Lordship, you have to be teacher, listen.
See,
In your,
cause is imposed not because we have the pleasure, the courts have the pleasure.
in your
Court is
ordinary,
imposed to let the officials know
exactly, Lordship.
of their duties and responsibilities. Not we have the pleasure of imposing costs. Not that. But we'll see. Yes. Mr. Kyangami, then Senior Government Advocate for the applicants, and Mr. Limawaman, Learned Counsel
For the sole respondent.
for the sole respondents. We pass the order. We will pass the order. For admission, item number 11. Yes, Mr. Takakicho. Your
Yes,
petition
Lordship.
has become infructious.
Yes, my lord.
It has become infructious.
Detention
See
order has
the
been,
order dated 11/3/2024. The third para, the detention of the petitioner has been extended by the impugn order dated 18/8/2023 passed by the Chief Secretary to the Government of Nagaland, as well as the order dated 24/1/2024, thereby extending the period of detention till 26/4/2024.
Yes, my lord.
Thereafter,
No extension.
thereafter, I think you have to apprise the court on that. Your government also, you are just coming casually.
My lord, we were to appraise the only.
Ah,
Yes. The matter is listed.
ah,
After the expiry of this day, the matter is listed today only.
Ah.
So we were to appraise today only. There is
Ah.
no more extension. So
Well, that information let the government get.
yes, my lord, I was about to make the submission.
Ah.
Till now, there is no extension order, madam. Since
Till
the-
now, if there is
since-
no extension order, then he has to be immediately released.
yes,
Yes.
my lord.
Correct?
Let him approach before the session court.
My lord,
Session
For-
court.
Yes. for
No,
the-
no, first
for-
we have to know
First,
whether there is
yes.
any extension, and then we want that from the government in the form of an address. At least, we want to be very sure to pass any order. We list it next week, next Wednesday.
my lord, since the detention, last detention extension was till 26 of last month.
Ah,
So today is the 12th day without
Ah.
any extension. So if any extension, even if an extension is made also,
Ah.
that will be illegal. And 12 days without any extension, so it will be illegal detention, my lord.
No, that
So,
is
my
why now everything,
May I pray?
if he is under detention, this is illegal detention. And in law, you have a right even to claim compensation.
My lord, may I pray?
But
Yes,
we want to be very sure whether there is any, because actually like you are making a oral submission. He is also making an oral submission that there
Yes.
is no extension after 26/4/2024.
my lord.
We would therefore like to know, at least by way of an affidavit, oath, that there is no detention after 26/4/2024. At least to that extent, we would like to satisfy us.
My lord, can it be on Monday, my lord? Because this is a preventive detention, my lord.
My lord, Monday, Tuesday, Wednesday, Monday.
What is the difference between Monday and Wednesday?
Friday, my lord, Friday then.
This Friday?
Yes, yes.
My lord.
Because next week I'll be out of station. I have some personal. Friday, my lord.
But Mr. Friday.
Yes.
My lord, if my.
No, Mr. Tiba,
Yes, my lord.
you can always entrust some of your friends.
Yes. Sir.
Because that is just to inform this court as to whether actually, like there is any detention after 26/4/2024.
Yes, I've received verbal information that there is no extension, further extension of that.
How can we take that
Yes.
on the face value? At least let the competent authority file a small affidavit.
Okay, my lord.
Okay,
Then next Wednesday.
not, your next Monday you're out.
Yes,
What
Monday,
about-
Tuesday, Monday, Tuesday. So, make it on Wednesday.
Well, make it on Wednesday, you're okay. Because in any case, if there is a extension, like if they are trying to actually cover up their detention by issuing a fresh detention order,
That will not
then
survive. Because the extension has to be given in advance.
yes.
And non-supply of the extension order itself is illegal.
In fact, we would have actually like passed the order to the, if there was any written affidavit from your side.
My lord, it is my humble submission.
Yes.
My humble submission that there is no extension till today. Till today, there is no extension. Even if
the state respondent extends with another order also, that will not survive.
No, that will not
So
survive.
in both the ways, my petition will survive. So may I pray that an order will be passed today. My lord, because it is 12th day without any extension, and this 12th day will be illegal detention. And my lord, why? Because this is with regard to narcotic cell Kohima case. The detainee, he was shifted down to Central Jail Dimapur because she was put under the PIT NDBS Preventive Detention Act. And now 12 days has elapsed without any extension order, and she has not been released from the Central Jail till today. So that amounts to
No,
illegal
she will not
detention.
be released if she is
My
involved in
lord,
other regular cases.
Yes, my lord. Even if she is wanted in that regular cases also, she has to be transferred from the Central Jail Dimapur to the District Jail Kohima.
Not necessarily, I think.
No, my lord,
Is
that
it?
is done. My lord,
I
that
think
is
that
done.
is at the convenience of the government. Where to keep you? You cannot have your choice.
My lord, but because I was in District Jail Kohima,
It's all
just
right,
the
even
moment
if,
I was served
see,
with the
even if
preventive
he is,
detention.
she is detained in Central Jail, Dimapur, you can always take a
Okay.
recourse.
My lord, so may I
You
pray?
go in any court.
May I pray
Competent
that
court.
even if the extension order is passed, that will not survive. So may I pray that an order may be passed today,
Hmm.
directing to release the detainee forthwith.
Both of you file affidavit. The government stating as to whether there is extension or there is no extension after 26/4/2024, and your affidavit,
My lord, do that effect if the state files, that will suffice, my lord.
Affidavit can be filed at any day.
Yes.
Before Wednesday also. The matter can be, of course,
you
taken up. with
you
the
can file affidavit and keep it in the registry even tomorrow. Then we will consider the affidavit on Wednesday, when you are here.
Yes.
At least furnish the copies to in advance.
I can do that this week.
This week.
Yes, sir.
Yes.
Friday.
What about tomorrow? Get a verbal instruction. Tomorrow is Thursday.
Only instruction I can obtain that one.
But instructions should be, we actually direct you to
Written.
get instructions and to
Tomorrow,
place the instructions before the court.
tomorrow I'm going out because I'm taking my father-in-law for treatment. So Friday, if it can be on Friday.
Okay, Friday you take instructions.
Yes,
Friday
yes.
actually, Mr. Yamarwati will not be there again. They have this Nagaland Bar Association. You entrust some of your this. Okay. But Mr. Shinzo Takakichu, counsel for the petitioner. Mr. E. Tibapong, learned governor Tuki, and Mr. Yamarwati, learned CPC. Stop. It is in from the order dated 11/3/2024 that the period of detention of the petitioner, of the detainee was still 26/4/2024. Stop. The learned governor Tuki shall come with proper instructions as to whether the period of detention has been extended after 26/4/2024. Listed on Friday. What is Friday? Listed on 10/4/2024. You come with instructions.
Okay.
Okay.
Much of it.
For orders, item number 13.
Yes.
Your lordships,
In this matter, I filed my takla this morning only for the private respondents.
For the
Respondent
private
number 4 to 11.
12 to
4 to 11.
4 to 11.
Yes. So this matter may be admitted and then
4 to 11. And
Lordships,
Madam, your home?
I'm appearing on behalf of respondent number 2 and 3.
2 and 3.
Lordships.
Mr. Sanso. Then Ms. Apila Santap. Then also for the respondent number 2 and 3. And Mr. L. Iramu. Then also for the respondent number 4 to 11. So Mr. Iramu submits that. You are filing your vakalat number?
I filed it.
What is your prayer?
The matter may be admitted for you.
Okay, Mr. Iramu. L. Iramu submits that. Since all the parties are represented, the matter may be listed for you.
Or should we, that can be, it may be listed on the 5th of June.
Listed on
5/6.
Okay. Yeah, yes. Okay. Listed on 5/6/2020.
For hearing item number 14.
Yes.
May I please the Lordship? Lordships, as per last order details, the Lordship has queried that if this Honorable High Court to take up this matter in the division bench or it would come before the single bench Lordship. And Lordship, as per Gauhati High Court rules, Chapter 2, Schedule 1 of the Rule 1, it has to be before the single bench Lordship.
That Mr. So-and-so. Then also for the appeal. Mr.
With on behalf of P. Paul, Lordship.
So-and-so. Learned Counsel. Appearing on behalf of Mr. P. Paul, the Learned Counsel for the respondents. By the order dated 3/4/2024, registry was directed to ascertain as to whether the present RFA should be listed before division bench or the single bench. So by the office note dated 6/5/2024, the registry, by referring to Chapter 2, Schedule 1, Clause 1 of the Gauhati High Court rules, states that, has stated that the instant case may be listed before the honorable single bench. In that way of the matter, list this case for hearing before the learned single bench. After 2 weeks. After 2 weeks. Okay. After 3 weeks.
So will the court sit again? Mm. Mm. So she was in a case. She was in a case.